Hello again and officially welcome. I'm Mary Yazdani, the host of today's webinar and the founder of GenesisLink. We are so glad you could join us for this important discussion on legal risks, IRCC audits, and protecting your client's PR pass. Our audience today is made up of SQV applicants as well as immigration professionals who work tirelessly to guide clients through the startup visa process, with the processing times being longer, audits becoming more frequent, and compliance growing more complex. Today's conversation couldn't be more timely. Before we begin, please note that today's session is intended for educational and informational purposes only. Nothing shared here should be taken as formal legal advice. Every case is unique, and we encourage you to speak with professional counsel for specific legal questions. A quick note of housekeeping: the webinar will run about an hour. We will have 45 minutes of discussion, followed by 10-minute Q&A. And also you can drop your question in the Q&A box as we go. We will try to get as many as possible. And I will give you a brief about GenesisLink. At GenesisLink, we specialize in supporting innovative startups and immigration professionals through the Canadian Startup Visa Program. And over the past few years, we have partnered with entrepreneurs, consultants, and legal professionals to help establish successful businesses in Canada. Our work spans business development, compliance, strategy, supporting the growth of companies once they land here. We believe strongly in bringing together industry leaders, applicants, and experts to share practical insight, which is why we are hosting this session today. Now it's my pleasure to introduce our guest speakers, Howard Greenberg and Naumaan Hameed. Howard is a highly respected lawyer with extensive experience in immigration law and federal court cases. He has guided countless SUV applicants and consultants through audits, fairness letters, and compliance issues. And his expertise on legal risk in the startup visa program is second to none. Our second guest today is Naumaan Hameed, co-founder of Greenberg Hameed and a certified specialist in Canadian immigration law with over of experience. Recognized as a leading practitioner, Naumaan combines innovation with deep legal expertise, making him one of the most trusted voices in immigration law today. Howard and Naumaan, thank you for being with us today. Let's get started.
Thank you.
Thank you, Mary.
Thanks.
Thank you, Sajjad. A pleasure to be invited today. We look forward to speaking to your audience.
Thank you so much. Howard, we are hearing that IRCC has increased the frequency of audits and direct calls to applicants. What exactly are they looking for in these reviews?
Well, let's start with the basics, Mary. They're concerned that the certificate and that the business plan reflects exactly what the founders are doing inside Canada. And so they have the certificate in one hand, and they have the business plan in the other hand. And they are now at the level of seeking inquiry from individual applicants as to what you're up to. By the time they're looking at your application and sending you the correspondence, a year or two has gone by already since you filed the application. There should be activity. You should be doing what you said you're going to do. The certificate should be consistent with your business plan. And the designated entity should have properly, given instruction and direction to the founders as they're developing their business in Canada.
That's really clear explanation. Thank you for breaking it down. And how can consultant and also applicant best prepare if they are contacted for an interview or for a file check?
Well, let's go back to what I just said, because we're getting these calls every day.
Mm-hmm.
You have to take out the initial certificate, take out the initial business plan that was done, and take out the fairness letter, put them all on the table in front of you and ask questions. Does this feel right? Have we made proper disclosure of the information which an officer would need to approve the application? Is there a reason for the officer to believe that we do not fully intend to get this business going the way we said we're going to do it? Are the essential members that we've listed in the certificate, are they actively involved? Do they roll up their sleeves? When we get to their applications, each one individually considered by an officer, will they be able to demonstrate that they're performing the activities necessary for an essential member to participate for a successful project?
Mhm. This is a valuable point, and just if someone is receiving an individual, an applicant is receiving a call and they are not ready or they are somewhere that they cannot speak, what the reaction should be. And of course, is a hard call, let's say, because it's something that, one day when they are not expecting, they receive a call, someone is asking them question about the startup business. So how they should react if they are not ready?
Well, the answer to your question, Mary, is they should be ready. So every designated entity and every consultant whose client has been filed should be pulling out their certificates and pulling out their business plans before the call and having a discussion as to what they understand the business to be. Who are actively involved in the business? Where are they actively involved? From Canada or their home country? If they're in their home country, what will they be doing in their home country that they can do in their home country as opposed to Canada? So there are a lot of preparation questions that must be posed between the consultant, the designated entity, and the founders of the business to make sure that when that surprise call comes in, they're fully engaged with immigration on the phone. They don't hesitate on the answers, and they understand their plan, their business plan.
Okay. And we had a chat before starting the webinar, and you have mentioned a valuable point that the things that they are saying over the phone is the evidences that they are somehow providing. And in case that now, afterward, they want to the federal court, this is going to be used, just, to be used. I'm not saying against them, but to be used. So, like how it's important to be prepared, but I would say from the previous chat and also from what you have mentioned, I would say that try to be prepared. If you got a stress or you think that you cannot just, answer right away, maybe have the call for the time that you are ready and be careful about the answers. Just don't answer because you want to provide some answers and just not saying that you don't know. Don't provide wrong answers or for the purpose of giving answer. So I would say that this is also really important because from our experience, we saw a couple of clients that they were so stressed. So they started saying something that was not true or it was not aligned with their business plan. But they said that we were so stressed, we didn't know what to do. So we were just, talking about some of the points in the business, not specifically the question that they have asked.
And that again, Mary, is why it's important for the consultant, for the founders, all of them, not just one or two of them, and for the designated entity to get into a conversation together as to what they understand when the project was presented to the designated entity, what the designated entity understood when they issued the certificate and provided the subsequent training, and what the roles and responsibilities will be after the certificates are issued, and why this is particularly important, Mary, and maybe Naumaan, please feel free to comment, is that by the time the fairness letter is issued, you can assume that 2 years, maybe even 3 years have already passed. So this is not day one. This is a point in time when that business should be actively pursued and developed. If it's not fully actively pursued and developed, there has to be some rationale as to why, what needs still to be done. And that should be understood before a call that comes out of the blue.
Yeah, no, that's an excellent point. Thank you so much. Let's get a sense from our audience. We are going to launch a quick poll and let's see what they think about this subject. How often have your clients been contacted by IRCC for audits or direct interviews in the past 12 months? Never, once or twice, frequently, and very often. We will wait few seconds here for you to vote. And while our audience are voting, let me ask Howard and also Naumaan, how often is happening for your clients?
Naumaan?
We've seen it, Mary, where it happens quite regularly these days is ironically on the work permit extension. So there's an integrity unit based in Ottawa, and these officers are looking to assist the adjudicating officer in getting relevant facts. And you described it quite nicely. They're reaching out unannounced, speaking to the applicant and asking very pointed questions, often on their familiarity with the business, their activities, what they've been actually doing and accomplishing in Canada can be very detailed. In some instances, do you have a contract? Have you made any revenue? Your incorporation? And if you're not well prepared, that's a difficult question to take on the fly. And that information then gets communicated to the adjudicating officer. And then ultimately a decision would come out. And they've been an extension of the officer to get that information, verified. And that's what we've seen on the work permit extensions. What we've also seen is that IRCC, we know that, previously NACO was the middle entity that was overseeing or expected to oversee the designated entities. It appears that IRCC is filling that role and asking more questions to understand what did the designated entity do, what did the applicant do. And so I think what we're going to see this year as a trend is more aggressive reviews to make sure that these decisions are fulsome, because Howard raises a good point. Some of these applications, for PR 3-4 years later, a lot has changed, and IRCC wants to know what has happened since.
Yeah, okay, perfect. Thank you so much. Let's also review the results. Never, once or twice, and frequently. Oh, that's good that 60% they never happened, that they were contacted by IRCC for audits, but it doesn't mean that it's not going to happen soon. Make sure that your clients are prepared. Naumaan, what are some of the most common mistakes you have seen in SUV cases that trigger refusals or compliance issues?
Yeah, it's a good question. There's a lot of issues, Mary, because we're seeing now many of the older cases are now in front of officers. One of the common concerns would be that an applicant and potentially the representative didn't fully understand the expectations of the program. So there wasn't a comprehensive business plan. There wasn't a full explanation as to how each one of the individuals is capable of executing the plan, a lack of critical information, and then changes. A really hot topic has been that a commitment certificate was obtained, but at some point after the 6-month period when the application was filed, subsequent commitment certificates were issued, sometimes adding a member, removing a member, changing the purpose of the business. And it was only last year in April where IRCC clarified that if one essential member files an application, no further changes can be made. But the problem is there were thousands and thousands of cases previously submitted where these changes have occurred. So, that's one of the issues we've seen. We've also seen the issue where language, for example, the language requirements were not properly met at the time of filing. They may have been submitted sometime after, but that technically doesn't meet the regulation. So there are lots of what we do at our firm is a health check. So we look at previously filed applications to try to spot these issues. Some of them can be addressed with an explanation, and other ones can be, quite problematic. And it's important that all the parties understand the risks.
Naumaan, just to make sure you've clarified this point, it's one thing to fundamentally change a certificate, and we know from the federal court cases that's just not going to work. That case is not going to be accepted. And it's another thing to have a business evolving over time, and when you're updating, you're not fundamentally changing the certificate, but simply updating the business as it was initially presented to be consistent with how it's developed in Canada.
Correct. So, quite regularly, things will progress over 3 or 4 years. They should progress. So updates can happen, but where you run into an issue is you've fundamentally moved from the terms of the certificate to the
Yeah.
point where the federal court had made a fair point, which is this seems to be a totally different business than the first business in which the certificate was issued. And you can't constantly change your business up until the officer approves. It's not fair. There has to be a lock-in time. So very important to think through those issues.
You have mentioned a good point, or interesting point. It was some fundamental changes, and it came to my mind that like if anything happens with the one member, which is not essential member, who is not an essential member, and they want to remove that one or this type of changes that is changes on the team members. Is this how they are going to treat this, especially as you have mentioned before April 2024? We had these cases, how they are going to handle it, and afterward, how they are going. Are they backdating those cases or they accept those ones, but not after April 2024?
We've seen litigation at federal court, and it seems that officers are applying the rules retrospectively. So I think if you have a file like that, you should take a look at it. Now, you raised an interesting point. There are different considerations if the individual who's no longer participating is non-essential, right? If they withdraw or if they're even refused, provided the business still makes sense and you've addressed the change, you
Yeah.
can still potentially be approved. Now, unfortunately, if after the first 6-month period a new certificate was issued and you added a new essential member or removed an essential person who withdrew their application, then the regulation technically can catch you, and that could be a refusal for everybody.
Oh, okay. Okay, that's interesting point. Thank you so much. And what's your advice for consultants who discover a red flag after the application has already been submitted?
Yes. So, unfortunately, because the policies are quite ever changing and the regulations are hard to understand, this can happen to an individual who's practicing. Our first advice is, find an experienced counsel to speak to and understand if you're not sure what is the significance of the issue and can it be managed. In some instances, certain changes can be explained, as Howard indicated, sometimes the business changes, but you have to look at it against the current policy and regulations and
Mhm.
then determine whether or not there can be a repositioning of the business, which might mean looking at the business plan, talking with the designated entity to make sure that they're still on side, getting a legal opinion on it. And in other instances, you might have to even look at some relief that might be possible under the regulations. There's something called substituted evaluation. So if there are certain types of deficiencies,
Okay.
for example, maybe there's questions about the ability to perform based on the language test, you might be able to provide additional information and talk about the economic value that might allow an officer to still consider processing the application, notwithstanding that there's a shortcoming in one area of the file. So I think that's the type of insight that you need to bring to those types of issues.
Perfect. Thank you so much. We have another poll for everyone. What type of compliance mistake do you see most often in SUV cases? Missing or incorrect certificates, unauthorized company changes like registry and ownership, documentation gaps or inconsistencies, and all of the above. We will wait a few seconds here. Can you tell us about your experience, Howard and Nauman? I think you are the one that saw most of these cases. So from your experience, which one is the most common changes and mistakes, compliance mistakes?
My first is if I was taking a test like in high school, I would go with all of the above, but would say some of them are more prevalent than others. For example, issues on the certificate are very common. That, but especially in past practice, is some entities, didn't get a lot of guidance in the early days about, how to approach that. And when you look
Um,
at the act and regulations, it talks about what you can't do, but it doesn't clarify exactly what you need to do. So I think there's a lot of confusion on that issue. And we do see the documentary gaps, like the business plan not being up to speed with what's actually occurring, those disconnects. and not so much on the shares. That's usually fairly clear, but I know we had a discussion earlier. Sometimes you can get into an issue when you're doing great as a business and you get a significant like VC investment that you might be diluted, and you have to keep in mind that you have to maintain certain share interest. We've seen that come up a few times, which is something you have to be aware of.
If I can add to that answer, Mary, sometimes there's different kinds of mistakes. There are mistakes, if you want to use that word, which are fatal. You can't come back from an essential a member withdrawing their application. There are not many remedies to that problem. The regulations are clear. One essential member is it withdraws, the whole all the applications go. So there are other mistakes which are not fatal, even if the officer initially thought they were. For example, we've had a situation where the certificate apparently wasn't delivered to, or IRCC didn't get the certificate from the designated entity when it was issued. And they took the position that that should have been delivered before the permanent resident applications were filed. They should have been, and therefore the regulations weren't complied with. Now, there could be a mistake there, obviously, because at the time that the certificate's issued, it should be sent to IRCC. But in the cases that we did, we pointed out that there was, although that appears to be a mistake, from our client's point of view, we sent in a copy of the certificate together with the application for permanent residence, and we could see no reading in the regulation which required the certificate to be sent beforehand. After consideration in a judicial review application, the IRCC agreed and can put the application back into processing because we did deliver the certificate with the PR application and indicated that new instructions were going to come out that wouldn't require a refusal of the application. So although there was a mistake made, not by the consultant, and not by his clients, by the designated entity, for one reason or another, didn't send a certificate or got lost, that's not necessarily a mistake that's fatal to the application. So every situation has to be looked at closely.
Yeah, that one is, I think it's an important one, as you have mentioned, and I believe our audience will say that, okay, what we can do, it's out of our hand. We don't have access to their portal to see what they are submitting or not. We ask them for the confirmation and they confirm that they have submitted. From our own experience, usually we ask the designated entity to send us the confirmation of submission. So they email the message, whatever that they are sending at the time of submission, we are asking them to send that and we attach that to the PR application. Maybe this is a good idea for the others also to follow, make sure that designated entities also are doing their job. They are not forgetting about it. Howard, fairness letters are one of the biggest stress points for applicants and consultants. What exactly is IRCC signaling when they issue one of them?
Well, it could be on any aspect. Look, it's open season on the applicants. An officer who's reading the application can look for any defect in the application, whether it's well, for example, do you meet the financial obligations both to support the business and to support yourself in Canada? And therefore, is the information and documentation that you provided sufficient so that the officer could understand that the money is there and it's your money? So there could be a financial inquiry. It could be on the skills level that someone has been put forward as a chief information officer, a technology person who's got no qualification in technology whatsoever. And so the officer is suspicious that that person can't undertake the role. And therefore, questions are asked about what your background is and how you can do that role. So every aspect of the application is open for review and consideration. And that's why in the applications that we handle, we have a very, very extensive discussion with the applicants at the time the certificate is issued to make sure that the right people have been selected in the right roles, are those essential members really the essential members you want to have in that certificate? And later on, will they be able to perform, or are they going to withdraw or not be capable? And are they going to bring everybody else down with them? So there's a lot of discussion that occurs on anticipating all of the different aspects of a fairness letter really early in the process, not when the letter comes.
Mhm. Perfect, thank you. And what are the best practices for drafting a strong response without over-explaining or creating new risks?
Naumaan, is this something you want to address, or do you want me to?
Sure. I think one of the issues, Mary, is firstly to understand that the procedural fairness letter and the reasons, they need to be reviewed. We've had issues where the policy that the officer was referring to contradicted the regulations. So
Mhm.
very carefully understand what is the confusion of the officer. And our approach has always been not to make it overly complex from a legal perspective. Help the officer understand what's really going on when there's confusion. Sometimes there's additional information that can be provided. It might be that we have to do a more thorough update on what the business has been doing so that the officer can see that the individual is genuinely committed to the business, if it's about whether or not this is a genuine transaction. But at the same time, we usually have two or three of us look at that because we're also, one eye is how do we convince the officer to feel more comfortable and hopefully move forward to issuing the PR visa. But also, did we get all the right information in front of the officer? So if they do end up refusing the case, we would make it clear that it was not reasonable because we've addressed everything comprehensively. So you're looking at convincing the officer, but also knowing that you might end up at federal court because this is a warning from the officer that they may very well refuse the application.
Yeah, that's a really good point, to have both sides in mind when they are responding, not only addressing the officer's question. And at what point, Naumaan, should consultant consider escalating to federal court? And what are the success factors in these cases?
Yeah, I would say, look, as soon as a procedural fairness letter is issued, personally, I think you don't want to respond to my point without putting on sort of your litigation cap on. So I would do it even before the procedural fairness letter, response is made and get advice. So that's done really thoughtfully. And then what really is important, I know we had an interesting discussion about even refusals, that there are different qualities of refusals. There are some refusals where when we look at them, and we'll talk a little bit later about AI technology and how these adjudications are being made, but it appears that the officer has fundamentally missed information that was on the application that would have addressed the concern, and they've overridden that information. So it's relatively clear on the face of it. And in other instances, we can see that there may have been confusion about the interpretation of the regulation. So it's incorrect. And a third popular instance is where a concern was presented, by the officer when we see the notes, but they never gave an opportunity for the applicant to even respond. So I would say those are like golden opportunities when a refusal is issued to challenge where from past experience, we would say that the chances seem reasonably optimistic. And then in other instances where we get retained late and we see the procedural fairness letter, we say, look, the officer is quite correct. Like, the issue that they pointed out is fundamental. Like Howard said, the essential member is no longer in the business and is withdrawn. Well, the regulations are the regulations, but I wouldn't take every case to federal court. There's a huge backlog and you don't want to waste the time and money. So the key is to understand the issue early and then make a reasonable decision.
Mary, can I just jump in a moment and
Oh,
just
of
discuss
course, of
a
course.
point with Naumaan? What's really important is that all of the submissions that you want to make are made to the fairness letter and
Mm.
not to the refusal letter. And I'll explain what I mean by that. If you're going to ask for substituted evaluation, a way of saying, look, okay, this business did not work, we're not within, the regulations to be approved, but I can economically establish well in Canada, and I'd like the officer to turn his or her mind to it. You should request that in response to the fairness letter, because the onus is on the applicant to put that forward before the refusal. So if the refusal comes and then you apply for redetermination, there is no obligation for the officer to consider a fresh argument for substitute evaluation. That officer would be correct in saying, you should have brought that to my attention earlier. I need not consider that now. So there are certain steps that you must take beforehand. If you want the federal court later to consider it, make sure that the evidence is there and it's clear that you've asked for everything you want in the response to the fairness letter. Because by the time you get to the refusal letter, you're only faced with the opportunity for a redetermination, and and the chances of the officer changing his or her mind on a redetermination are considerably low.
Perfect. Thank you so much. I sure that many of our audience, they were just, they got good insights from both of your insights and also responses to these questions. And that's great for everyone to know and consider it from earlier stages rather than waiting for the time that the application is refused and then they don't have any room for defending the application. Yeah, that's great point. Thank you so much for sharing with us. Let's hear from our audience. When facing a fairness letter, what is your biggest challenge? Understanding what IRCC is signaling, drafting a strong and concise response, knowing when to escalate to federal court, or managing client expectation and stress. What is your biggest challenges? I would say that is managing clients' stress is not challenging, but it's the first thing that it comes. And I would say that if we put ourselves on their shoes, they want to make a big move in their life, and of course, that letter is going to question everything and the whole plan that they had and the time that they waited for a couple of years. So that's a big one, but.
Mary, if I can respond a moment,
Sure.
we get a high number of telephone calls from consultants who are faced with a fairness letter, and their clients, obviously are in other countries, and they're very concerned about, are they going to succeed? And one of the things that we do is have a clear conversation with the consultant that they didn't do anything wrong, that there are a lot of gaps in the program. The regulations aren't very complete. The officers misunderstand information, or the fairness letter highlights areas which they shouldn't highlight, that it's not part of the application. So that goes to speaking to managing clients' expectations and stress. What the client has to understand is that the system has some frailties to it. It's not the consultant's fault that this letter came out. These letters are common. The right actions were taken by the consultant, and there's a misapprehension of the application, and we need to put it back on the right track again. That's a really important point.
Yeah, thank you so much. I think that's the important part. And the consultants here, our audience, they love the comments that you made, because sometimes no matter what the rejection letter is or what is in the progress, or the clients, what I saw is that because they are in too much stress, the first thing that it comes to their mind is that, oh, our immigration consultant was not good, or the
Right.
professional that was helping us, that's their fault because we did whatever that we were supposed to do, or we were told to do. But that's a great point, that necessarily all the reasons or the just, everything that they are putting on that letter is not necessarily true or because of a mistake.
We get on the phone with the consultant and the consultant's clients. We act as a sounding board. And so after we have a good discussion about what has occurred and what's in the letter, it maintains the relationship between the consultant and the client, because all of a sudden they're not adversarial. People aren't asking for their money back or angry. They all understand how the system works, and this is what they need to do to respond.
Exactly. No, that was great point. Thank you so much. So Naumaan, for work permit holders in Canada that they are waiting for years for the PR decision. Oh, sorry, we didn't review the poll results. Perfect. So my apologies. 45% drafting a strong and concise response. 36% knowing when to escalate to federal court. Managing client expectation or stress, 18%. Perfect. No one, so it's good that for everyone is clear what IRCC is signaling. That's at least good news, and everyone, I think, agree on that. Thank you so much for the responses. We will go to the next section of our discussion, and that one is work permit for the startup visa. Work permit holders in Canada, you know, that they are waiting for a couple of years for the PR decisions. What are the biggest risk for these clients in prolonged backlog situations?
Correct. It's become quite a pain point, Mary, because these individuals, if they were fortunate enough to get the initial work permit, they've convinced an officer. But you're right, you're talking about 52 months before you get to the solution of PR. And so in the interim, they have to potentially, if we've got a 3-year open work permit, they might have 1 or 2 of those potential extensions to make happen while they're in Canada. And so they're exposed to much more scrutiny, right? In terms of when an officer looks at an extension application now, they want to see over a fairly long duration, what have you done? And their expectations are higher naturally because you've been in the country for a longer period of time. So it's really important that you have a robust update to your activities, that they line up with your business plan. We see that as being an issue. We had a good discussion this morning about the calls that are coming, to make sure that there is in fact genuine activities. You're not just doing other things in Canada.
And Naumaan, maybe discuss that in terms of an activity tracker, evident.
Right. So what we do, which we felt is necessary, and it really covers you from a PR perspective and a work permit perspective, is that there is an activity tracker that we provide to applicants. And, we filed a very high volume of applications. So when we see the latest questions that are asked by officers, we add that to the activity tracker. That gives structure for every team member to know what they should be doing, a checklist of activities, so that when they are asked, either if they get a random call or if they're doing an update to their PR, or when they're filing a work permit extension, they can document in detail exactly what they're doing in the business. It's been very helpful.
Yeah, that's right.
Yeah. And those are the types of questions that come up. The other issue, Mary, that comes up quite a bit is these individuals often have high costs. They come to Canada, they're investing in their business. They may have families, so they've got accommodations, which are very expensive in Canada. Cost of living is expensive. But when you file the application for your work permit, you still have to meet the settlement funds requirement, and work permits are taking about 230 days. So throughout that entire period from the time of filing, even when they're making a decision, an officer can ask for you to update your financials. You must make sure that you have met that requirement, that you have those funds. And in a number of instances, people from certain nationalities have faced currency depreciation too. So not only holding the money, but monitoring if your foreign currency, when you exchange it to Canadian rates, still
Inflation rate also.
great. Yeah, lots of moving targets there.
That's a hard one. And what strategies can consultants recommend to help clients avoid work permit extension refusals?
Yeah, the first thing is, don't assume that the checklist is going to be the standard for approval. It isn't. You really have to make your case. The other issue that comes up is, what is a significant economic benefit? Can you articulate what you're doing and how it meets the requirements of your original certificate? And you should detail that. We've seen refusals where the officer wasn't convinced at this juncture that that benefit was there to warrant the issuance of the work permit. And then, of course, the activities, robust activities that are detailed. And what we do, which is a little different, is we've seen, and we know that AI is, 3,300 officers have been reduced. The processing demands are being increased. So officers are spending less time on files. Sometimes we've seen that, they've been using a system called Chinook to triage and give risk profiles, but often the refusals are not, in our mind, justified. So what we try to do is we try to anticipate the common issues for refusal and address them, head on. One of the common ones we discussed is refusals where they feel like the individual will not return to their home country, despite the fact that they've applied for a permanent resident program, and despite the fact that Justice Diner has given a very detailed opinion that that's not reasonable under the program. So we believe, and there are a number of instances where you should proactively educate the officer to try to make sure that some of these common grounds, number one, don't come up for refusal. And number two, if they do, you can do a reconsideration, say, hey, we raised this point on page 7. It's right there, right? So you have to think ahead in these applications.
Yeah, exactly. Especially for the startup application, I think is different with the other immigration streams. That is a short application. It's really to the point. It doesn't have that much information that is required beside the just education, the experience, and the personal documents. But this one, there are so many long documents that maybe the officer doesn't have that much time to go through all of them. So it's good to address and bring it in front of the eyes. At least hopefully they will reconsider the decision.
Correct.
Well, thank you so much for bringing the AI things, because that was my follow-up questions and this is a question that every month we are asking our guests, that how do you see, have you ever seen or experienced any cases, any refusals that you felt it's because of the just, AI, or it was a wrong decision? When I'm saying wrong, I mean that the reasons for the refusal were not logical. And you pointed out well that Shenak, usually when you're asking for the officer notes and you're seeing those things, you know that that's coming from that high risk and also making a rush decision. Thank you so much for bringing that up. And let's have our last poll, which is for your SUV clients already in Canada. What is the greatest risk you worry about? Work permit extension refusal, PR refusal after a long time, business traction not meeting expectation, or all of the above? This time I will vote for all of the above. And usually, I remember that those days when I was in high school, in any test that we have for all of the above was the right answer. None of the above or all of the above was the right answer most of the time. Perfect. Let's see what are the responses so we can go to more. Perfect. PR refusal after a long time, and business traction not meeting expectation. Oh, no one just voted for that. Surprisingly, I was surprised to see this. 55%, all of the above. Oh yeah, 55%. I was saying why no one voted for work permit extension refusal. So it seems 55%, they worry about all three options, and I think that's normal. All of them are equally important. Howard or Naumaan, it's up to you. Which one of you want to answer? But from your perspective, what proactive steps can immigration professionals take to protect an application during the waiting time?
Naumaan, I think that probably we should concentrate on the activity tracker and updating the information. Nothing is more difficult for us to deal with is a fairness letter where the information is 2 or 3 years old, and no one has really talked to the founders in the business about what they need to accomplish to succeed and what the officer is going to look for. So interestingly, I was discussing a case yesterday with one of the lawyers in my office that was transferred over to us from another lawyer. And I said, what's happened on the case since filing? And he said, nothing. They thought their role was simply just to file the application, that they charged a fee. And I said, well, who's been talking to them after that? And they said they didn't think they should anymore. That's all they were hired for, was to file the application. I don't think that that's the case. I think there's a continuing obligation on a lawyer to file the case and then stay close to changes happening in the business, constantly have a dialogue with the client, and the client would feel better about it knowing that the consultant was involved and and cared. 2 years is a long time to wait for a response, maybe even 3 years.
Yeah.
And we haven't talked about mandamus yet. I guess that will come up shortly. But there's a point in time at which you got to have a decision.
Yeah, thank you so much. And I wanted to ask that why this is important. I think you explained it, why this document management and updating those file management thing is important. I want to ask you one question, that what level of details this documentation needs to be? Let's say they are saying that we develop our MVP. So what type of and how much details from that is required or it will be asked by IRCC? Is it showing them the prototype, or having some letter of intent from the potential client saying that, okay, having some pilot customers, what level will satisfy them first, and on what level of just detail they have to document these things. As an example, we have a client that part of the application development, it was talking to different doctors and specialists to get the signs and also the idea, the pain points. So they did over like 100, I don't know, 150 interviews with different doctors, which was taking so much time. And, that was a big activity. Is it only one line that we conducted 100 interview with doctors, or that should be more analysis of those ones and also adding their findings?
My preference is, the more information you have that demonstrate the genuine efforts and how you did it, and the details and the findings, is more likely to be persuasive for an officer, because the test, it really comes down often to whether or not this is a genuine or
Mhm.
artificial transaction, right? Section
Uh,
89. And so,
So, mhm,
yeah, I think where you have, there's a balance here, right? On one hand, you want really good detail on things that are consistent with what the basis of the commitment certificate was and what was said in your business plan, what happens generally in your industry and that business, and then showing what you've done. Now, where we've seen, the opposite is where people are sometimes too optimistic, or they present targets that the officer then looks at and says, I don't buy this. You're suggesting you're going to generate $3 million in year one? No way. That doesn't happen. Right. So, when you talk about too much information, too little, it really depends on what we're talking about in the application. And then what we always look for is consistency between the commitment certificate, between the business plan, and then in the industry, what's happening. And I think that's sort of the test that one should look at in determining how much information to give. And keep in mind, officers, they already, if it's a proper SUV application, it's probably already around 200 pages. So you don't want to be dropping, 100-page updates on them. Otherwise, it's going to delay your application.
yeah, okay, perfect. Thank you so much. And I think that's good to understand. So there is not any general rule of how much details. It depends on the question that they are asked for, and on what level of details that answer provided by them can be convincing to the officer, and saying that this is not a made up story, that's saying that, okay, we did this, show me the proof. When you are breaking down the details or some of the evidence, some of the pictures of, for example, for those one, or deep analysis and detailed analysis of those interviews, for example, that can be that can be convincing enough for that officer to check mark that, okay, this is address and I'm convinced now. Okay, that's a good point. And because sometimes I believe that applicants and also immigration consultant, they are looking for one specific answer, one specific list of questions that IRCC officers are asking, or checklist that they have to check mark, saying that, okay, this is the progress, we did it, check mark it, so we should be good to go. The point is that what a legitimate business will do to operate or expand in a country, that's what you need to do. It's not any predefined checklist. Perfect. And this takes us to the Q&A section. Already in some of the questions that I was asking you, it was the question that was submitted by our audience during the time of registering for the event. And thank you so much, both of you. It was really insightful, the information that you share with our audience. And I wanted to ask from our audience to type their questions in the chat if they have any new question that we haven't addressed it yet. And also, I will start with the questions that we haven't addressed them so far. And then if we have time, we will go through the questions that they are typing now. If you had to give SUV applicants one single piece of advice for staying compliant while waiting, what would it be?
Maybe I'll start with that answer. Start with the certificate, then do your business plan, and then ask the question, have I been following the certificate and the business plan? To be compliant, I would have to be doing what I said I'm going to do, have enough money to perform the activities I'm performing, and be able to show that the business is real. So almost every inquiry we get in our office, our usual response is, we'd like to see the certificate, we'd like to see the business plan, and then we'd like to understand from you how much of this you've accomplished, and are the people participating in the activities the way you initially represented.
Okay, perfect. That's a great advice. Thank you so much. We will go to the next question. Are there situations when responding with too much detail in a fairness letter can hurt a case?
Yeah, I would say yes. I mean, what you want to do is address the concern that's been raised because a decision hasn't come out yet. Now, if you provide a number of other pieces of information and you're not careful about what the officer's mindset is, you might be providing more information that they can use in justifying another concern. So I think you want to be specific to the issue at hand and be careful about not providing any information that might address other issues.
Great, thank you so much. Looking ahead, do you expect IRCC to introduce new SUV program guidelines before 2026?
Maybe I'll start, Howard. I think we will have to wait and see from the minister's perspective that, a new immigration plan will come out, what the thinking is around the levels. We've had a lot of discussions with the department. They very much are in favor of the merits of a program, but it seems like they want a properly administered and a program that attracts the right types of people with the right intentions. It feels to us like this is a year of compliance and integrity in the SUV program. So I think things will tighten up and we'll have to see what that looks like in terms of format. But I think there will be changes, but there is enthusiasm for a properly administered program.
Perfect, thank you so much. And I believe by September or October that they will announce the new targets. We'll know a little bit more, maybe more details or afterwards. From your experience, how often do federal court cases succeed in overturning refusals?
We haven't done an analysis of all of the cases, but there's a fair amount. There are reasonable prospects with a good case in federal court that the judges will agree with the applicant and send it back again for reconsideration by another officer. So the federal court is a reasonable alternative when there are no other alternatives.
I'll just add on one more comment to that, which is, and it sounds like the lawyer answer, but it depends on the facts and how the refusal was made and what evidence was actually submitted. So sometimes on the face of it, and we had a good discussion, Mary, where you see in the GCMS notes, Chinook was used, and you see that the officers raised a concern, but on the file, there was evidence that addressed that very issue. Or the officer seems to have raised another issue, but never put it to the applicant. And so these types of issues, when that's the issue we're dealing with, what we've seen is that not only can you get a favorable decision, at the federal court if it goes all the way, it might even be an issue that could be settled and redirected. And keep in mind, there's quite a backlog now at the federal court. And so there's probably, and I don't, know this officially, but probably incentivization to only use the right resources for cases that deserve the judge's attention. So we've used that effectively to advocate for our clients where we feel like reconsiderations don't work, but when you have a good discussion and a strong position, you can get that file reopened quite quickly.
So your suggestion is that not all the cases should go to the federal court, only the cases that they have good evidence and okay, perfect.
Correct.
And not all cases will go to federal court. We've been successful in negotiating settlements of cases with the Department of Justice and IRCC after filing our documentation where it was clear that our position was the right position and that they were not confident that they would win. So you really didn't have to wait for the federal court case to come up in a year or two later. It was at a very early stage we were able to get a consent, an agreement to strike out the decision and to go back and have it relooked at.
Okay, perfect. Thank you so much. We are at 11:58, so only we have 2 minutes left, and I have in front of me 5 questions for you that let me pick one of them randomly because even I don't have time to go through all of them. The one that is shorter. Is this okay not to apply for work permit extension if they are here with the work permit?
Well, firstly, it depends on where you are in your business and what you're planning to do. And to Howard's point, what's in the commitment certificate, what's the business plan, and the type of development or activity that you're doing. If it can be done and there's a reason why you might have to collaborate, for example, back home with a development team, then it could be justified. But it should be, again, it should be done thoughtfully, and that we should think if we're not extending the work permit, when we're asked about why we didn't, what is our explanation? And does it seem reasonable and rational in terms of what the business is trying to do? So I would think of it in that context. And I see, and I'll try to wrap up another one really quickly. There's a question, should I apply for a work permit? Like at the
Yeah, I wanted to mention that it's
that's kind of connected. Really, look, some commitment certificates make it very clear that there's an urgent reason why essential person must come to Canada. And if you never apply, that will be a question that will be raised unless there is a reason. Like there's been a change and a business change and the business plan has been modified and it makes sense. And you're delaying your entry until a later date because maybe there's some additional work that you need to do before you're actually going to be market facing. So again, there's a reasonability test and the key is to think it through, document it before you make that decision.
Perfect. Thank you so much for the valuable answers, both of you. And thank you, Howard. Thank you, Noam, also for, again, accepting our invitation and participating in this webinar to be our guest. And thanks to all of our audience who have joined and engaged with us. At GenesisLink, we are committed to supporting immigration professionals and SUV applicants with the latest insight, strategy, and tools to help you succeed and protect your clients' futures. We will be sending out a replay of today's session and additional resources. Also, and Naumaan and also Howard will give us the points, the main point of the discussions that we had since we cover so many things. They will give us they were nice enough to just, offer us a point of the subjects that we have discussed, and they were important for you. We will send over that one to you as well. Please stay connected with us on LinkedIn and through our upcoming webinars. Once again, on behalf of GenesisLink, thank you for joining us. Have a great day, and thank you so much again, Naumaan and Howard.
Thank you, Mary.
Wonderful day. Thank you.